Our colleague Joseph Akable has been speaking to Dr. Justice Srem Sai, who is the Deputy Attorney General, and the issue is still on the removal of the CJ. Let's take a listen.
So hello and welcome to this special conversation with the Office of Attorney General. Our guest today is Dr. Justice Srem Sai, our Deputy Attorney General. And Doc, thank you so much for agreeing to speak to us.
Yeah, thank you so much for giving me the opportunity.
It's been a busy last couple of months, particularly with the issues surrounding the Chief Justice, the former Chief Justice, and the process eventually terminating, the President writing to communicate that to the former Chief Justice. From the perspective of the Office of the Attorney General, what's your own assessment of that entire process that has taken place?
Thank you very much. I think this situation has given us a very important lesson in our strive to run a democracy. Issues have been raised on the independence of the judiciary. On the other hand, issues have been raised on rule of law. Opinions have been offered on whether the process is correct and whether it should be changed. One thing which, however, stands out is the understanding that everything that we do under the Constitution must conform with the provisions of the Constitution. And this process in particular has been tested, whether or not it's conformed with the provisions of the Constitution. It's been tested in at least 5 cases in the Supreme Court, 2 in the High Court, and the conclusions have been the same. In fact, every aspect of the process has been tested in the courts, and the conclusion has been the same, that it complies with the processes with the processes prescribed in the Constitution. And for me, that indeed is what rule of law is about. The fact that actions, whether by the President, whether by the Council of State, or whether by the two of them combined, could be tested in court to see whether they are indeed in compliance with the Constitution. I think the process has survived that. I refuse to mention that it's been tested in the ECOWAS court as well. From where I sit, I believe the outcome would not be different from what the courts of Ghana have given. So I would say that indeed it was tested. It has passed the test, not from my perspective, but the perspective of the courts.
But from the perspective of the AG's office, do you find that the process that the former Chief Justice went through was a fair process, such that she had an opportunity to put across her case fairly, and the conclusions reflect what should be the conclusions?
So let me begin by saying that this office would never condone any unfair treatment of any public official or any Ghanaian. That is the fundamental, that we occupants of this office will not sit down and oversee or condone or partake in a process which we know is unfair. From that, I believe that what I have to say is that by the standards of this, by the Constitution, and this office is completely and absolutely of the view that the process complied with the law and has been fair, it has been reasonable, it has been legal.
I mean, the President's role, 2 key roles. The first had to do with receiving the petition itself. Then eventually he did a prima facie determination in consultation with the Council of State. That particular determination has come under some scrutiny. We've heard from a former Chief Justice who has said strongly that from the letter that has been written to the former Chief Justice, Justice Gertrude Tokonu, she does not find the conclusions, the 3 issues that were relied upon to form the base of the removal. She does not think that it even crosses that minimum threshold, bringing into question the determination that was done by the President with the Council of State.
Well, it's a very difficult one to take from a very respected former Chief Justice of this Republic. She's demonstrated her competence for so many years. She served her term without blemish. She's been recently, even going beyond the law to, contribute to public discourse on various aspects of of the country, sectors of the country, economy and all that. We may all have our opinions on how things are supposed to be done. But we also know that due process is the answer to some of these contentions. I think the issues are two. We are looking at, we need to make a choice as a country, as a people, okay, as to the standard which we hold public officials. We need to make a choice. My understanding of the Honorable Retired Chief Justice's argument is that not that a wrong has not been committed, but that a wrong was committed, but it is a kind of wrong which should be allowed because of the person or the office involved. I think that is my understanding. I don't know. You interviewed.
Yes, I mean,
do I represent her fairly?
I mean, to an extent, I mean, largely. I mean, I wouldn't disagree at all. But I mean, if you pick one of the grounds, for instance, so the bit about the travel expenses, her response is that, well, if the auditors had any concerns, the auditors should flag it. If there is to be a refund, there has to be a refund. So she doesn't understand how that, for instance, should amount to stated misbehavior.
We're in this country, okay, I think it was when Parliament approved the spouses of presidents to be given some monies or emoluments. The issue went to the Supreme Court, whether it was valid, right? I think the Supreme Court decided that there is a process through which you should go to include persons, and that so long as that process has not been followed, you cannot say that it is lawful to make such payments to the spouses of presidents and the vice president. This is even after Parliament had made a recommendation. You know, it was tested in the Supreme Court, and that was the outcome. So, why should it be that the president can't at will give money to people? Even Parliament cannot at will give money to people, spouses or family members of the president, and then in another case, we would say that it is, you know, we should. And the question of, I said it's a question of standards, you know. Maybe it is, we have to make a choice as a country whether we want our leaders to be excused from some of these things so that they can do it, and then we just ask them to return the money. Recently, where I sit, I prosecute people, okay? So many people in this country, when they commit a certain crime, we jail them 5 years, 10 years, and all. So if the position is that we should excuse leaders or those who are at the top of the, let me call it the political food chain, to do certain things without holding them to account, we can adopt that as a country. And if the other school of thought is that for persons who are at that level, they should even be held to a higher standard, in the sense that they know, they know and ought to know that this should not be done, right? So if they allow that to be done, we have to decide that we will leave them to go or not. But I believe that the standards have been considered by a panel of 2 Supreme Court judges and 3 other persons, with the former, auditor, general. I would defer to their, conclusion as against their appreciation of the standard as against the former Chief Justice.
But do you not see the point she makes, perhaps, that to the extent that she doesn't control the purse? I mean, she's traveling, they make arrangements, they give her what they ought to give, and eventually now it turns out that, well, what she has received is in breach. Should that not cure it? Should that be a basis for a removal of a Chief Justice from office? Do you think that that is not a bar too low? What do you make of that?
She was given, and she received it, and she didn't do anything about it. So she should be allowed to keep it. It doesn't sit right with my thinking.
Okay.
It doesn't.
But how about the role of the auditors? I mean, at those levels, because that's why auditors, exist in various agencies.
Auditors have given their reports. Is that not the case? The reports were given how many years before this hearing? So if there was any attempt to remedy the situation, it would have been done. And I don't think there was any attempt. I think the issue was whether the now outgone Chief Justice is entitled to it or not under law. The committee says she was not entitled to it. I don't think it's a question of remedy as the former Chief Justice is putting across. It's a question of whether a wrong was done. And I don't think that the argument before the committee was one of whether it should be remedied or not. The committee, what I understand the committee to have said from their conclusion is that it is something that ought not happen, and it happened. And so the conclusion was that if it's stated misbehavior. The stated misbehavior simply means that something which you shouldn't have done, considering where you are. So it shouldn't have happened. Whether the former Chief Justice received it or whether she gave it, it shouldn't have been done.
I mean, the other issue had to do with the appointment of Superior Court, specifically Supreme Court judges. And again, the former Chief Justice takes the same position that she had written. And particularly, she makes the point that to the extent that there doesn't appear to be a clear-cut procedure in the Constitution, even though the various age arms that are supposed to participate are mentioned, we do not know how it commences. From whose office should the names come up from? Should they start from the Judicial Council? Should they start from the Office of Attorney General? And that in that regard, if she has written a letter giving such names, she doesn't think that sidesteps that process. Is that something you are...
There is a fundamental rule of, principle of law. For a public officer, you have no power to do something unless the law authorizes you to do it. So if you do something which the law doesn't authorize you to do, there's a process called writ of quo warranto. If you are going to court, they'll ask you, who gave you the authority to do that? By which mandate did you do that? So this is not the first time we are proposing persons to be appointed to the Supreme Court. The constitutional law has the letter of the law, it has its spirit, it has conventions and practices as well. So the impression should not be created as though nobody ever knows how to appoint Supreme Court judges. It should not be said that we don't know how the list, is generated. The question is, do you have the power to generate lists? If you have it, you've not done anything about it. If you don't have it, then there must be some stopgap. I mean, we cannot allow. Right now, there are things that I can do, and there are things that I can't do. If I don't have any authority to do something and I do it, I think I should be ready to accept the fact that I have breached the law, and not create the impression that nobody knows how to do the thing. So I'm doing it the way I think it should be done. There have been so many countless under the 1992 constitutional law. There have been so many appointments. Currently, we have we've had 18 persons on the bench. All of them were appointed, and they all went through a process. So it cannot be that we do not know how a person is appointed to the Supreme Court.
But to the extent that the recommendation went, the appointment was not even done, do you still think that, as far as you are concerned, that meets the standard as well in terms of crossing the threshold? So
the appointment didn't go through. Why? Because some people stood up to authority. I think that is what we should be concerned. So people risked their liberties, their everything to stop it. So, and you know what it takes to oppose people in authority in this country. So if it was stopped, we shouldn't say, I don't think that it's a very strong argument to say that it was stopped by some people, so we should let it go, or we shouldn't think about it.
I mean, what does the office feel generally about the former Chief Justice, Sophia Kufu's comments on this process, given the position that she occupies, the body that she belongs to basically took part in the process, and she's publicly raising such matters about the entire process that has taken place?
No, I have this is my personal opinion on the matter. I have a very liberal outlook to some of these things, okay? I think there is an issue on board, the former Chief Justice feels strongly to comment, which I believe she has the right to do, is for the public to assess the quality of the comment, the weight to put on it, and within the context of what you have said, that having been part of the process and having testified,
and she was a member of the Council of State.
Council of State, then she came and testified,
yeah,
in the committee. So I think I would take the Honorable former Chief Justice's comments as re-echoing. She has already taken side by going to testify, even though I don't know whether it was expert's opinion or expert witness or just to testify to the facts. But the point is that she has taken part in the proceedings, has testified in the proceedings. So coming out to repeat the same thing, I would take it within that context. That and I think the Honorable former Chief Justice also said that she's not ashamed to support. I think that's the.
In fact, she said if she had the opportunity, she would do it again.
Yes, so she is supporting the former Chief Justice. That is her position. So I think she's entitled to continue that support.
I mean, earlier on, you made a point about concerns that have been raised over the period about judicial independence. There are those who look back at those comments and they make a connection that there was a clear discontent that even the current president, he publicly, made that comment many times about the need for judicial reforms, that it is that commentary prior that has been engineered in a manner that fits within the current legal framework to reach a certain conclusion.
No, that is misplaced. I mean, it is completely out of place to suggest that because there was a policy, a campaign proposal or policy that the judiciary will be reset, then it means that anything that happens within the framework of the law is to malign or take away the independence of the judiciary. That doesn't connect as far as, and I believe you should agree that it doesn't connect, because does that mean that because the president made that promise, so if there is any wrongdoing and the petition has been brought, the president shouldn't act on it because it will be said that, it will be a very difficult argument to carry through. So for me, the reset agenda has to do with institutional, structural, changes in not just the judiciary, but all arms of government. And you can see there's a constitution review process as part of the reset. We have 24-hour economy, which is part of the reset. We are looking at so many other aspects in terms of education, how school fees are paid. That is part of the reset. So you cannot reduce the reset agenda to a petition brought by how many people gone through the process as an indication of that. Look, the judiciary needs a lot of structural, logistical, changes. We are still here doing paper filing. Cases drag on for years. The average time for a criminal case to terminate, even a summary trial, is 2 years. 2 years. So if you arrest someone, unless the person pleads guilty, if you want to take the person through the criminal procedure, the shortest time limit for you to get conviction is about 2 years. That is not right. We sit in this country, we saw things happen in other jurisdictions. Someone is arrested, and within a few months, they've finished the trial. The person, if jailed, has been jailed. Some people even finish serving their term before a simple case. So those are some of the issues that the reset agenda is talking about. We are talking about electronic, assistance with the court system. Those are the issues, and to strengthen the independence of the judiciary. Now, let me flip even to another point. Now, let's look at it this way. Is it the case that whenever a Chief Justice is removed, then is an attack on the judiciary? Or when there is accountability, persons in judicial office are held to account, then it's an attack on the judiciary? Or is it that the office of the Chief Justice is above the standards or is above the law? What exactly is the point? Because this is also not the first time that we are seeing a justice of the Supreme Court. Well, this is the first time a Chief Justice has been removed, this way in accordance with the Constitution. But other justices and other persons who are ranked in the same, at the same level, have also gone through this same process and have been removed. And I think the time they were being removed, there was no question as to whether it was a question of whether it's an attack on the independence of the judiciary.
Do you share the fear that some have expressed about the ripple effect, the likelihood that more petitions will be coming through, not necessarily in the immediate future, but potentially when there's a change in government?
No, I don't have any fear. You see, there's no fear about that. If an occupant of an office, as the office of the Chief Justice, is removed based on merit and is subject to the process of the law, why should we look? It is really, for me, it is better, okay, to have Chief Justices change frequently for a better judicial system than to have Chief Justices stay for a very long time when we have issues with justice. So I personally don't have any problem with justices changing, so long as there's merit in it. If you appoint a Chief Justice today, and tomorrow, even under the same government, tomorrow there's the Chief Justice does something which warrants removal and is removed, with all due respect, I think that should be accepted. It also has another dimension, that then it means that persons who occupy that office would be able to, keep themselves above certain, standard. But a situation where it's as if we don't want to hold Chief Justice to account, or that we want to lower the bar for, persons who occupy certain offices because of where they sit, I think that is more dangerous than anything.
But if the change should be taking place based on which party should be in power, that will not be good for the country.
Those who make that argument, is it the case that they want the Chief Justice to, it's a process, okay? So long as you're able to prove that, one, incompetence has been, if you're able to demonstrate that the person in office has been incompetent, if you're able to prove that the person has misconducted him or herself, or that the person is infirmity of mind and body, that is the principle in the Constitution. 3 grounds. If you're able to satisfy any of the grounds, the person goes. And I wouldn't be looking at the fact that the person is coming with the president and is going with the president. And would you want a Chief Justice who has misconducted him or herself, or who is incompetent, to remain in office across presidents, or you will want Chief Justices to be effective in their offices across presidents? I think that is where the question is. Do we want a certain standard to be kept, or we want just the person to be in the office for as long as we want? Don't you think that there's another side of this which would keep the occupants of the office on their toes? Because, for example, when I listen to the former Chief Justice, I get the impression that she herself probably had been doing some of these things when she was, or did some of these things when she was in the office, because clearly she didn't think it was a big deal, right? Let me ask you, is it a big deal to you? No, I want you to, is it a big deal to you? This, the allegation we've heard, which is not being denied by saying that it is just something small, is it a big deal to you? If it is it? I want to know first.
To the extent that a committee has looked into it, I think what we have as a fact-finding matter is what a committee has put out there. But I'm asking you, in your assessment, a direct question, which I asked. Let's
summon this first. No, let's
yeah,
summon this first.
Yeah.
You see, the former Chief Justice is not saying that the allegation is false. Her position is that
it doesn't meet the standard.
It does not. It is normal. Let's let it go. Let it slide. Which gives me the impression that perhaps even when she was in office, probably she was doing the same thing. And I'm asking you.
That would just be an assumption that you
that is clearly an assumption. That's why I said it's an impression. Now I'm asking you, is it cool? Is it cool for you for such things to be happening?
I would want you to answer that. I would want you to, because the point I'm making is that a committee has looked into the matter, but from where you sit, I don't know to the extent to which you've seen all the processes, which we may not have been able to see. A direct question to you: do you think former Chief Justice Gertrude Tokonu misconducted herself?
The committee's findings shows that she did. And I have no basis to question the committee's conclusion.
From your independent analysis, you agree with that conclusion?
The truth is, I don't have the facts and evidence that was put before the committee. I didn't witness anyone being cross-examined. I couldn't have formed an opinion different from that of the committee. But
the allegation that has been put out, to the extent that we know it, at least the letter that was written, it summarizes those 3 pointers which we've discussed. You hold a view that those allegations can form a basis for that conclusion, if they are proved at trial.
Yeah, I think the question is, if they are proved, why not?
Okay. And another question on that.
And here they've been proved by the committee's finding is established.
Another question on the issue that I asked about fairness. Do you think the former Chief Justice got a fair trial, if I'm to put it that way?
It is fair, because personally I was involved in. I conducted all the cases in defense of the Attorney General, in defense of the committee. I was the one in court, and my argument has been one that is fair. It is legal. It is fair. It is reasonable. It meets all the constitutional standards for administrative, inquiry.
In terms of the conclusions that the courts reached in some of those decisions, I mean, I remember one that you had the judicial review application at the High Court. You had raised the issue that the matters that are in contention have been dealt with at the Supreme Court or remain pending in the courts in one way or the other. There are some who have questioned that decision, for instance. Then they make the point that the grounds for judicial review are different from, for instance, if you go to the Supreme Court to seek to interpret or enforce the Constitution. So judicial review will deal more with the procedure, whether there's been a procedural breach, rules of natural justice, all those matters. And they say that the court could not have relied on those pendency of those matters to conclude in those ways.
No, then those who say that probably were not very familiar with what happened in the High Court. The High Court, the question was substantially whether the High Court has jurisdiction to determine a matter in respect of which the Supreme Court is either seized, or has already made a decision. And the merit of the case was about the process that is ongoing, which has been brought before the Supreme Court. So if you say that the High Court judicial review process is to look at the process, the Supreme Court is already looking at that. And it was sent there not by, the Chief Justice was one of the persons who sent the matter to the Supreme Court to review the process. So the process having been subjected to the Supreme Court, scrutiny, it is improper and abuse of the court process to bring the same issue to a High Court, knowing very well.
That those grounds are not the same, because the grounds, if a matter is taken for interpretation and enforcement, and you make a judicial review application, the grounds which you'll be urging on the court will not be the same, correct?
Well, I don't think the matters that went to the... I am arguing the case, and I'm telling you that it's the same issues. Going to the Supreme Court, the question, most of the reliefs were whether, for example, you need to give a reasoned prima facie, conclusion. It's about the process. The question is whether the committee members have sworn or were administered to the oath of office. It's a process question. One of the questions was whether the Chief Justice, could be about the document being served on the Chief Justice, whether she has been given some. Those are all about the process. So I don't see any. The main cases before the Supreme Court are not about interpretation at all. About prima facie, about in-camera hearing. Those principles have been interpreted in several cases even before this time, and the Supreme Court has a standing, position on them. And in such a case, Supreme Court will not reinterpret something that they have already, interpreted. So they were all about the process, the fairness of the process.
Okay. Let's talk on two main issues, then we'll wrap up on this subject. The first one is the ECOWAS matter that is pending. Where are we on that aspect?
Yeah, so when the Chief Justice, former Chief Justice, approached the ECOWAS courts, raising the same issues that were raised in Ghana, which the courts have been, seized of and have ruled on at the court, at the ECOWAS Community Court, and she applied for interim measures, let me call it interim injunction, so that listeners would understand that the Ghana government, the government should be ordered to withdraw the suspension that was slapped on the former Chief Justice, and also that when the matter is determined, she should be awarded $10 million damages, $10 million as in damages. Those were the issues, but we objected to the jurisdiction of the ECOWAS court, saying that the court doesn't have the power to assume jurisdiction over a matter which the local court, that is Supreme Court of Ghana, is hearing, and the court, ECOWAS Community Court, doesn't have any power to interpret Ghana's constitution for us. Those were the objections we raised on the jurisdiction of the court. This morning, we woke up to a new process. So the court is here to rule on the objections. Yeah, the objections that the court adjourned since that was in June to give a decision on the matter. There's no decision yet. This dawn, we woke up to another process which was served on us from the court, that the former Chief Justice is seeking judgment in default of defense. In other words, that we've not defended the substantive suit. We had 30 days to do so, and that we have not filed our defense. But our preliminary thought is that if we are objecting to the jurisdiction of the court, and the court has taken argument and has adjourned to give a ruling one way or the other, we do not exactly think that we have to file on the substantive issue, because the question before the court is whether the court has jurisdiction. The court has to clear that aspect first, and when it says that it has jurisdiction to assume, then they will order us to file our defense. And indeed, if the court was interested in getting the court could have ordered that we should file our defense together with our preliminary objection, because we were heard. It's not as if we argued that matter in court, in the ECOWAS court, and we were heard. And the court in adjourning didn't give any further direction. They told us that they are rising, and then they have adjourned the case, indefinitely. And when they come back, they will give us further directions. So we were waiting for the court to give us further direction, only to be served with a notice for default of defense. So that is where we are at the moment.
So what are the next steps? You'll be applying for that to be thrown out as well?
Yeah, we would have to file to oppose the application for default judgment, because, like I've explained, the court did not order us to file our defenses.
You're a legal scholar yourself. The outcomes of that court decision, we know how our jurisprudence operates. Does not, even if we sign treaties, it do not automatically become law here. The outcome of the decision, whatever decision will come from the courts eventually, how do you see it playing out here in Ghana? Yeah,
so currently, because the ECOWAS court has not been incorporated into our legal system, the decisions of the courts are sent in to us here in the Attorney General's Department, and it's an executive. Within the framework of government, we have the executive, the legislature, and the judiciary. The fundamental principle is that in dualist countries like Ghana, the courts do not see international agreement unless they have been ratified by parliament into domestic law. Then the courts can see it. So the Supreme Court, technically speaking, cannot see whatever, or is unable. All the courts in Ghana are, let me put it literally, they are unable to see what is happening in ECOWAS, because we have not domesticated the ECOWAS. However, governments can decide. That is, when I say government, I mean the executive. When it is served on us, the government of Ghana as the executive may decide what to do with the decision. And that is not to say that I have predicted what government of Ghana would do. Government of Ghana would decide whether to grant the award, or, if the court grant the award, whether to pay or not to pay. Whichever way, the ECOWAS court can hold the government of Ghana to not comply with the decision, because we have signed an agreement. So at the international level, the ECOWAS court is also not aware of the divisions we have in Ghana's executive, legislature, judiciary. They are aware of government, Ghana as a country. So if they give a decision in that court, as far as they are concerned, the decision must be implemented. If we do not implement it, it could be enforced at the ECOWAS court. But the court of Ghana are not aware of these things. I'm saying it in a very vivid form. They are not aware, or they don't have what it takes to see what's happening in ECOWAS because Parliament has not yet opened their eyes to what's happening in ECOWAS. So it's a dualist situation. We have domestic law, we have international law. A lot can happen there without coming into domestic law.
A more direct, simple question for an ordinary man. In the event the court, one of the preliminary measures she was asking for was that she should be reinstated when the suspension was enforced. If the court says she should be reinstated, what will happen?
We'll cross the bridge when we get there.
And finally, on this CJ matter, I mean, do you think the entire Article 146 procedure needs an overhaul? Particularly, the problem sometimes is the judicial decisions, which some say that has complicated things to the extent that even though they are reading into the law, they do not provide clear text how it takes place. So they make reference to the JHU matter on prima facie determination. So it has put it in there. It doesn't tell us at what stage should a person be heard. Is it before? Is it when the president receives it immediately? Do we need to have a clear overhaul just to make things more predictable?
So I believe in a living constitution. What it means is that the constitution would undergo reviews either by legislative measures, by judicial decision, or even by practice. You know, these are some of the ways that constitutions grow. The fact that constitution can grow, the fact that we think we can improve our constitution, doesn't mean that what we have is terrible. You understand? So, for example, if the argument is that the process is not detailed enough, of course, we can make constitutional instruments or we can make other laws to detail out the process, which is fine. What I do not subscribe to is to say that because of want of that, what has been done is wrong and is unfair. You know, that is where I have a problem, because you can't tell me that, for example, you said the Constitution didn't give the specific number of days that you should return a prima facie decision, or the specific number of days that the committee should conclude its decision, or the details. So because of that, then whatever has been done is unfair. That argument doesn't wash. But if we say that, okay, we have gone through a process, we have identified a few things that we can improve upon, so let's take steps to do it, fine. But that does not invalidate that which has been done under the law as it is.
Let's talk about Oral now, Operation Recover or Loot, a big campaign promise before the government came into office. Almost 9 months down the line, 2 cases, the SkyTrain one and the other one involving the former National Signals Bureau chief. Would you say Oral is on course?
Oral is very much on course. It's so much on course. And sometimes I look, you know, as I sit here, I look at the Ghana Police Service, I look at Yoko down there, and I see BNI on the other side, and beneath where I sit are hundreds of attorneys, and they're having sleepless nights, you know, investigating. So let me take this opportunity to explain the process of the criminal procedure to the public. I think when I do that, it will at least let the public know what is going on, so that the allegation that, or the complaint, I understand the complaint, okay? Because so much, you know, a lot happened in this country, the citizens became aware of it, and they are eager for justice. And I understand that, and I subscribe to that eagerness. And actually, every morning I get not less than 100 tags on social media. And out of those tags, about 99% of them are asking me what is happening to Oral. And I read them every day. And I thank you for giving me the opportunity to address that. So to take someone to court for a criminal, you know, trial, first of all, there must be a complaint. The Oral Committee, which was set up immediately after the election, their main job was to assemble complaints, because that was a time when people did not know exactly where to go to make complaints, or people have even lost confidence in some of the law enforcement institutions. They are not sure that if they go and give a complaint to, let's say, institution A, it will have any effect. So the Oral Committee was to serve as that assembly point for various complaints. After that, so they compiled their complaint. you cannot go and arrest someone and throw the person to jail or take someone to court merely on complaint. There must be investigation. So that's the next stage of the criminal process. So after complaint, you come to investigations. Now, investigation means that all those allegations, our agencies, National Security, NIB, that's National Investigation Intelligence Bureau. No, I think it's Investigation Bureau. And then Police Service, IOCO, they are all out there, and what they are doing is to find the evidence to support those complaints. Because the persons who bring these complaints are not law enforcement. They may have an idea. Some of them may even have some document that they believe is enough, but it doesn't mean that we can go to court with what they brought. So these institutions are day and night going out there, gathering information. That is why you see sometimes when they arrest some of the people, you see the public, they'll go and gather at IOCO, or they'll go to BNI, or go to police service. That is all part of it. I can tell you a significant number of people who are going through investigation, no one knows about it. They come quietly, they go through the process, they go, they return, they go, they return. So because I am here, I know what is going on. We can't always come out to be announcing every aspect of these things, because when we do so, chances are that we are also being unfair to the persons who are involved, because investigation may lead to no finding against you. Yet, in society, when you are invited by police and you put it out there that this person has been invited, people conclude. So we can't put everything out there. Now, after you gather the evidence, the next stage is for you to build a docket. The docket is for all the attorneys to come together with the investigators on each case to say, we have enough evidence to go to court with. Then you now begin, so it is when the docket is built and we have charges, that is where you see me running to court to go and charge the persons, like the Edubuahene case and the Sky Train, and then we charge the person and say that you have committed this, then you defend. Then the court trial itself starts. I mentioned earlier that the average number of 2 years. Now, let me give you these two cases that you mentioned. We have moved so fast within these cases, okay, to the extent that for Edubuahene, we are about 1/3 through the case, 1/3 of the journey through the case. If not for legal vacation, which stops the courts for 2 months, we probably would have closed our case, and then the defense will be open. But we will come back in October and then continue with where we left from. That is super fast. That is very, very fast if you compare it with all the other criminal trials that we are even doing here. But I understand, I know after this, I'm sure one of the bites you put out there is that Deputy Attorney General says oral is super fast. So then the public will say, but we don't see anything. But the point I'm trying to make is that the expectation is legitimate because of what we have witnessed. But the work we are going through and we are doing is very thorough and is vibrant. I hardly sleep. But the bigger point here is that the public would have to, as it were, be also made aware of the processes. That we can't just bundle people based on complaints and throw them into jail. So someone says 8 months down the line, nobody's in jail. We have done 8 months. We don't see anybody in jail. The people are still walking about, and some of them are giving interviews. But there's no law which says that if you are being prosecuted.
In fact, they've made reference to the National Service Secretariat one. The lady involved that the Attorney General spoke about her. She participated in a recent GFA event, and we saw, if you go on social media, you see the comments. People are saying, that all what the AG said, how is the matter not in court?
Yeah, why is he still contesting and winning election and we are here? How is Edubuahene granting interview and talking about Omani being his good friend and all? We have to, there's nothing really we can do as law enforcement about people's rights to contest, because the position of the law is that you are innocent until you are proven guilty. The person has not been proven guilty. So for the public, let me make this point, that the concerns are legitimate. There's no doubt about that. The concerns are legitimate. But the processes of the courts and the criminal procedure is also, you can't, there's no point in rushing, and at the end of the day, the person will just be discharged, So what I can say to the public is that my good friends out there, they should keep the pressure on us. They should keep the pressure on us. We need the prompting, we need the pressure to be motivated to continue the work. We are motivated, but without their constant reminders, without their constant tags, and without their constant, calls on us that we should move fast, chances are that we may feel complacent. So we agree with what they are saying, but we are following the process, and I'm saying that we will deliver the mandate that they have given to the government. President John Mahama's government's promise is that we are going to correct all the injustices that have been done to the public purse. We are going to ensure that people are brought to book and examples are set for people to know that when you abuse public office for private gain, when you take public resources and you pass it off into your pocket as your own property, you will be dealt with. And that agenda is on and will not stop. And the motivation that we get from the public comment is also very much needed.
On the process, the agencies that work with you, or basically under your supervision, YOCO particularly, in the last couple of months, the concern has been the bail bond, the sum that they are fixing. I mean, the argument is that sometimes they fix huge sums in a manner that basically they've granted you bail, but you end up being kept for more than 48 hours. I mean, your ministry is responsible for justice as well. And when you're in private practice, I remember you've raised issues with how bail is handled generally. Do you find this to be consistent with the legal provisions, Article 19, Article 14?
Yeah, so I understand the public concern, but this is what law enforcement and even the courts take into account when they are granting bail. They look at how much is involved in the alleged crime. They look at the possibility of the suspect or the accused person running away, that is flight risk. They look at the possibility of the accused person interfering with further investigations or trying to pervert the course of justice if he's granted liberty. Now let's focus on the value involved. I understand why the people are shocked about, or they feel that the bail bond, the amount is huge. That is because the crimes we have investigated are unprecedented. I mean, someone is alleged or has been accused of taking 500 million Ghana cedis, and then the bail is, you want the bail to be 2 million. I will pay the 2 million and go and not come back. Do you get the point? So the bail, as the courts themselves have decided, should match with the gravity of the offense. That is what it is. So if a few of those cases have moved from the law enforcement, have gone to court, and even where court granted bail, it was still difficult for the people to satisfy the condition. For example, in SkyTrain, one of the accused persons, after being granted bail, was still in custody. It took the person a very long time to satisfy the condition in terms of the amount. What it means is that the law enforcement agencies and the courts have agreed or are agreed on the gravity of these bail conditions. So, yes, it may be outrageous to you that someone is supposed to pay millions of cedis for bail, but we need to also find out what amount of money the person is accused of stealing or of misappropriating or causing financial loss. And when you look at that, you will see. So, for example, some of the people who have brought the suspect, investigation showed that they have properties that are more than what you think the bail is. Now, if you give a bail condition which is below, and the monies they are accused or they are alleged to have stolen is also huge. So you sitting out there, this is huge, 2 million is huge. But the person deep down his own heart knows that, look, if I can look for this money and pay, So I don't think that the courts have been excessively harsh, and the few times that reviews have been sought in respect of those bail conditions that the law enforcement agencies have granted, the courts have marginally remained within the same framework, and people still struggle to satisfy those bail conditions.
In terms of the practical aspect of it, first, the person is presumed to be innocent. When you are arrested, they can either release you conditionally or unconditionally. when they fix the condition and the person can't meet it, where do you stand? Within the 48 hours, should the investigative body go over to court to get a remand, or they should simply say that, well, we've released you, meet the condition before you go?
So, if you read the law says if you arrest someone, you present the person to the court of competent jurisdiction for his liberty to be decided. That's the position of the law. So, the investigative authorities also have a mandate, a command actually under the court to send the person to a court of competent jurisdiction for the bail condition for the person's liberty to be decided. But that doesn't also prevent the accused person who also has the right to go to court. And in most of these cases, what you would realize is that you need to distinguish between what is actually going on between the accused person and the investigators and what is happening outside on the street by supporters granting interview and saying most of the people carry themselves as lawyers for the accused. But as far as the investigators are concerned, there is another lawyer who is the lawyer for the accused and is dealing with them on very...
I mean, we saw it in the Wontumi
case when one lawyer is roaming in town, granting interview that he is the lawyer, saying all manner of things, when the proper lawyer who is dealing with it is also saying completely different things. So my point is that we should be also very careful how we classify some of these complaints. Because if, as a lawyer, if I go and I see that the bail condition is excessive, what I will do is to file a court for a review or compel the law enforcement to produce the person before a court. But you would, almost all the cases, you see that the proper people who have the instruction of the accused person, they don't go around complaining. They work around to satisfy it. Then some other lawyer who has no instruction from anyone is passing himself or herself off as a lawyer for the accused person or the suspect and is saying all manner of things. So as far as law enforcement is concerned, we are dealing with a lawyer who is most of the time in agreement with what we are doing and knows that he is in there, he knows the allegation, he has seen the complaint, he has seen the evidence to some extent, and is complying with the law enforcement agent. Then a lawyer who has not even gotten access to the person in custody, let alone talk about even assessing evidence, even knowing the complaint, also on social media saying, or in the media saying something else. So we need to draw a line between those complaints and what the legitimate lawyers, duly appointed lawyers, also say.
One aspect of the oral that has also been criticized has to do with how cases that existed already in the courts have been handled. I mean, one of such matters involves Dr. Kobna Dufo, the former finance minister. From where the office sits, all the commentaries, the analysis that came post that decision, is it the position of the office still that we got a good deal that the country made a benefit from us against if they had followed through with the prosecution?
Thank you very much. You see, the best deal, okay, is to retrieve all the monies and jail the person because he has breached the law. That is the best deal, okay? But when you come to plea bargaining, we are not choosing between the best deal and the worst deal. Of course, if we all have the chance, as a law enforcement agency, we will collect the money and put you, in prison on top, because the law says you can even do both, okay? But the fact that we are coming to plea bargaining, we are comparing the time, resource, and the money that goes into, litigating for years, and the time value of money, and trying to reach a settlement. I understand plea bargaining is new in this, in our country. So a lot of people find it strange that someone has stolen, and you say you are stolen, and then you said you should bring some of the money and keep the rest so that you go and chop. If that's the case, then it's always better for us to all steal. Then when they catch us, we'll give some to the AG's office, and then we'll go and chop the rest. But let me explain something. The same, I was happy, but it was very instructive to me that after the Dufo settlement was announced, the following day we had the other one.
The Republic versus
the beige. Yeah, the beige one decided. So compare these two. Situation one, the Dufo case, we were able to cut our losses, and then we got as much as 60% of what we allege that has been, as a subject matter of the crime. Okay. Then compared with the other one, where the person ended up being, acquitted, we got nothing, zero. In fact, let me not go further, but we even stand. There's even a possibility that, there's something called malicious prosecution. So that can also be consequence of what happened. So I understand that we always deserve the best, but sometimes you don't have the option to take the best or the worst. You are choosing between two worst options. And in this case, we chose between, in the Dufour case, we made a choice between getting 60% and getting in the Hinaku case, the choice was between getting the best and then we ended up getting 0. So we need to look at it in this light. I also want anyone who has committed crime to be punished, and I want all the monies to be retrieved, but it's not that simple.
Will it not have been more reassuring if it had been done under the recently passed Plea Bargaining Act, which is basically it would have to go to court for the court to adopt it? The agreement that was reached with Dr. Dufour.
That is one way. In fact, under the plea bargaining, that's just one way of doing it. There's another traditional way where you enter nolle prosequi and still get the same result. So it is not. There's not one way to doing the thing, and there are so many factors that are considered even a plea bargaining. There are so many factors that are considered. I wish. You see, we have given explanation as to what informed our decision. There's not sufficient space to explain and also to tell all the other things, because as part of the agreement to settle, not every part of the consideration will be made public and all. And it is sometimes painful, even to those of us here, that we do not have the unlimited space to give explanation or to explain to every person as to what went into the decisions. But I can assure you, my boss loves this country. The president of Ghana, JM, loves this country. There is no way JM will sit anywhere and look at Ghana losing and approve that Ghana should lose this. There is no way my boss will look at Ghana losing something and say that. And I think that is the essence of electing people into office. When you elect someone, I think the meaning is that we trust that this person, when it comes to determination of certain issue, he will be able to make a judgment which will be in the public interest. And I think that bit is reassuring to me, that I have a boss who will not stand anywhere and say that he's going to bend the rules so that somebody will go. And I have a president who will not sit anywhere and preside over things that will cause losses to the public. So the decision was made with all the relevant factors considered, and we believe that that is the best that we could get under the circumstances.
Where are we on the regional tribunals?
Yes, so the bill is pending before cabinet, so that will be implemented, and it is a very important aspect of this government's reset agenda to bring back the regional, not to bring back, to activate, because actually in the constitution it is not something that is dead. It's just that we were not using it, so we are going to start using it, because it is part and parcel of the laws of this country.
And how different would you attempt to limit their jurisdiction so that it does not appear to be doing the same things that the ordinary courts will be doing?
No, so the regional tribunals deal with crimes that are of public interest nature. It doesn't mean that the High Court doesn't deal with, so their jurisdiction actually overlap. The only difference here is that the regional tribunal has built in itself an inbuilt component of active citizen participation. So sometimes we lawyers see things differently from how non-lawyers see things. So for example, every lawyer who knows how criminal procedure goes would never say that oral is slow or oral is not happening. Because every lawyer who has gone through law school and is worth his salt will know that it will take you an average of 2 years to complete one criminal case. So, but the public may not know this, right? So the difference here is that the regional tribunal will now include the public in the justice delivery system to know that, so their views are also important, because they said justice emanates from where? The people. And it should be exercised in accordance with the will of the people. So the people's view of what is just is the most important thing in every jurisdiction. Let me give you an example. So for a greater part of human history, we use other means of trial. We use trial by combat. People actually believe that when there's a dispute between a land dispute, you bring your strongest person from your family as a claimant, and the defendant bring the strongest person. And when they fight, and whoever wins is the one who is entitled to the land. There's no logical connection between the strength of someone and the land, but people have believed in it and have used it for far more longer period than this system of justice we are using. People have used trial by ordeal. Human beings have used all manner of, we see people going to even religious, they do trial by religion and all that. So what matters in a criminal, in any justice system is the people's perception of justice. If the people believe that what you are doing is unfair, it doesn't matter how you explain it as a lawyer, it is unfair. And they will consider it unfair no matter what. If the people think that it is fair, then they will appreciate the justice system and they will uphold it. You know. So what the regional tribunal does is to bring that component of citizen participation so that the citizens' view, so it's a blend between what technical law is saying and what the people's, view of justice is.
And with the bill that you've seen so far and the possible implementation when it takes off, those who have fears of the public tribunals in times past, they can be assured that that will not be the mode.
No. You see, things begin. Look, even the idea of democracy. Democracy was started by a very bloody, I'm not talking of Ghana, the idea of democracy or representative democracy was started with a very terrible history. But we have refined it and now we are here as we are happy whenever we say democracy. We don't even think again, we think it's the best form of government. Even the current justice system that we are running, its history is not pleasant. But we have come to improve upon it and we love it. So the argument that the public tribunal was used to be very crude and used to punish people, therefore this is what we are bringing back. It shocks me when the argument is made, and I know people who sometimes make it mischievously to create disaffection for the process, but there are enough guarantees. For example, it's the same Chief Justice who empanels the court, who will be empaneling the persons who sit in the public tribunal. It is the same judges or lawyers, persons who are qualified to be judges. So you cannot sit as a judge, as a panel member in the regional tribunal or the public tribunal unless you are qualified to be a judge in the high court. So it is just, the only difference here is that you have the public actively participating in that trial. The criminal procedure is also the same, So there shouldn't be any fear whatsoever about how that justice system will be implemented. Nobody will be brought to public and caned. Nobody will be stripped naked and lashed at the tribunal. No, you are entitled to your right to counsel of your choice. You would open your case, you will cross-examine your accusers. They will come and testify in court. You also call your witness, the same process.
Finally, let's talk about legal education. We have heard from various individuals suggest that there is a major change coming up, reform that will see universities allowed to run a professional law program. Is that, can you confirm that as the approach?
Yeah, that is true. So the bill currently is on my desk. It's on my desk. I'm doing some review, and I'll have to forward it to my boss, which then will be sent to cabinet for approval. And this is what we are looking at. First of all, the bill will separate regulation of legal education from regulation of law practice. Because currently, the General Legal Council plays the two roles. It is regulating legal education and is regulating law practice. So the first purpose of the bill is to separate it. There will be a different body responsible for legal education, regulation in the country. And when I say legal education, I'm talking of professional legal education in the country. So that is the first point. The second major thing that the bill will do is to take away legal education from the hands of those from the hands of judges. GLC is basically judge heavy in terms of its composition is and give it to the universities. So the universities will be accredited, which will run the law practice program. That is what we call the Makola program. So, for example, if you go to University of Ghana, after your LLB, University of Ghana will be running the Makola program, which would be regulated by the new body that will be regulated.
You mean all universities, not necessarily University of Ghana.
I'm just using I'm just using University of Ghana as an example, but any accredited university, and it's not going to be all universities. Yeah. It's going to be universities that have been vetted and given accreditation. And some of the factors that will be considered in giving accreditation is your faculty strength. That is the persons who are teaching in the university. Are they persons who are really qualified? Do you have those people in-house? Not situations where you would be some people. I mean, if the school doesn't have a library, it doesn't have a moot court facility, its quality of staff is weak, you may not be given accreditation. But if the university has all these facilities, and we are strengthening the regulatory mechanism in the sense that if the bill is passed, there will be regular assessment of accreditation. So it's not as if when you are given accreditation this year, then forever you will just go and sleep and then you will still be running the program. So we believe that it democratizes access to the legal education.
So you do 3 or 4 years, depending on whether it's postgraduate or main at the university. Then afterwards, what happens?
Yeah, you do 1 year. It may be, we are still fine-tuning that. But what we are trying to do is that we offload a number of the subjects that are currently being treated at the law school, professional law school level to the faculty. Because something as conveyancing could be treated if the faculties that the universities are teaching land law. So why can't they add conveyancing to it to round up something as even technically speaking, a course like where are some of these?
Criminal procedure.
Yeah, those are procedural courses.
Interpretation.
They'll be kept in the law professional law program. But most of the courses that burden law students in the law school will be transferred to the university level, and then it will be taught there. So it will be part of your LLB, and we will set some minimum standards in terms of the courses that you have to pass to be able to enroll onto the professional program, even in the same university. Okay. So the fact that you are finished Legon doesn't mean that you can automatically, you need to do some minimum required courses to be able to qualify to be enrolled onto the Legon program for the law professional courses.
And when you complete that, you take an exam?
Yes, there will be a bar exam by the National Bar Council. So there will be a National Bar Council. So you don't come to any law school in Makola anymore, but when it's time, you apply, you sit for the exam, and then you take it. We are even considering the number of times the exams will be conducted every year. So it may be 3 times in a year, it may be 1 time in a year, but we have not yet reached that point. So that is what we are looking at.
What becomes of the Ghana School of Law, which you attended?
Ghana School of Law belongs to, GLC is an Attorney General Department.
Okay.
So it's our building, the facility is ours. So we may use this for other purposes like training our lawyers or training investigators, but that decision would be, when you look at the lawmaking process, we have to do other consultation after the bill is drafted and everything. So those are some of the possibilities. And we have post-call people in the system. So maybe Ghana Law School will be used for, running programs for post-call people or other people, but it will not be the same Ghana Law School where everybody must attend for 2 years to become a lawyer. No, that will change.
What timelines are we looking at for all of this to take off eventually?
No, so it will be sent to cabinet in I think that's next month. I'm almost done with my review. My boss will have the finals look at it, and then it will be sent to cabinet for consideration. So by the end of this year, we hope. It's a parliamentary process. Once it goes out of our hand, it's in the hands of Parliament. But if we look at the timelines in Parliament, we believe that by the end of the year, it would have come out as a bill, and hopefully we'll start the implementation the following year.
2 quick issues, then we are done. One, the anti-LGBT bill. We know that the claim was that it died with the previous Parliament. That was the concern. The President even said that as well. Where are we on that now? The President had suggested to the Christian community the possibility of it being a government-led bill. I saw a story suggesting that it had gone back to Parliament. I don't know what you know.
I would have to confirm where it is at the moment.
Okay, but what's the government's approach? Is that the approach as put out by the President possibly?
Yeah, the President's position is what the government's position is.
Okay, and finally, one question I left out of our earlier conversation. When can we expect the vacancy to be filled, the Chief Justice?
The President has not made his view known yet, but I believe it should be done as soon as possible. Yeah, I don't have any, it's above my pay grade.
But what will be the considerations, in your opinion, because of the sensitive nature of the position, what we have experienced in times past? perceptions about the judiciary?
It would definitely be the same consideration. Who
outside of the constitutional requirements, outside of that?
Yeah, I mean, it would be who the president and the Council of State believe to be competent to be the Chief Justice. It could be from the current composition of the Supreme Court. It could be from outside as well. These are all possibilities. So let's restrain ourselves to the eligibility criteria.
I've seen a story that is already saying that the acting Chief Justice is to be appointed.
He is eligible, very much eligible. I mean,
is he in consideration? Do you know?
I don't consider the appointment.
Do you know whether those
it's above
who consider are considering?
I can't know. I can find out, and when I find out, I'll let you know. But currently, I don't know. Okay. But he is eligible. Obviously, I mean, he is eligible.
But what would be the, I mean, what's the, in terms of the matching orders, if I'm to put it to that extent, because of the context, what has happened over the years, the concerns, we've seen Afrobarometer reports, something definitely drastic has to happen in terms of justice administration to restore confidence to an extent.
Yes, so that is true. It is one thing that as a Ministry of Justice, we are really concerned about. And let me tell you something, and I want, you see, the Ghana Bar Association need to confront something which is very, very important. You see, a lot of people and a lot of lawyers complain. Where I sit, okay, complain. When I meet friends who are lawyers, they complain about something. People are willing to pay money for other purposes to get justice than to pay legal fees. Yeah, people are willing to use other ways of getting justice than to pay legal fees to lawyers. So lawyers are losing business. Lawyers are losing business. What does that tell you?
That there's a lack of confidence in the current system.
Yeah, because you need to, if you go to court as a lawyer, you are speaking law. You have to predict. Lawyers, one of the writers said we are prophets of the courts. We only predict what would happen based on what has been happening. That is the strength of our job. So based on what the courts have been deciding in the past, we can say that because the courts, when A and B happens, the court have said it is C. So when we are going to court and we are advising our clients, we are advising you with the understanding that you will get C because of what we know has been happening. If we fail in predicting that, or we don't have any basis to make those predictions, the public will lose confidence in us. And I think that it is a call on all of us, not just the two of us who occupy these, offices, but with the support of Ghana Bar Association, with the support of the legal community, the Association of Magistrates and Judges, we should be able to solve this problem and regain confidence. You have said that people don't have confidence.
I mean, that's what the Afrobarometer report says.
And it's true. So we need to work on that. We cannot continue to sit and be talking about all the things except the one that matters. We need to, because I am a lawyer. I spent my whole life training, educating myself, preparing myself to do this. What profit would it bring to me if I don't have a client who is willing to pay me for doing my work, and I don't even have confidence in what I would do? I mean, what the outcome of the court would be. And it's something that I expect GBA to be very, very active on.
Just a final, I know I said finally already, the Office of Special Prosecutor, so far, the work that the office is doing since the new administration took over, are you satisfied with it?
Satisfied. They have some challenges. I really would wish things could move faster, but I also understand the challenges. So let's hope that things get better.
If you say things could move faster,
and
it's like you're talking about something that we don't know. You know.
No. I think generally, just as I was here defending myself about people's call for speed, and I think it's the same call on the Office of the Special Prosecutor too, except that here we have huge volumes of cases. They don't have much of that, but the same call is going to both of us. So, and I believe if you speak with a special prosecutor, he would also, and you ask them, they would say the same thing, that they wish we could also move faster. But I think the commitment is there. The commitment to bring law people to face the law is there. We have some logistical challenges, but that shouldn't be an excuse. We should be working with whatever we have and give the result that the people want.
Thank you very much, Doc. That has been our conversation with Dr. Justice Srem Sai, Deputy Attorney General.
Joseph Akable, thank you very much for that one. Well, you've been watching TV3 New Day, and that will be our show for the day. But before we go, you still can win 2,000 Ghana cedis right now if you already got in the game, *439#. Let's see who our third winner of 2,000 cedis will be. The rest, of course, will be dished out off air. So that's the number, third winner for the morning. 0599-660. 3 numbers come after that. Congratulations to you. We've not done birthdays in a while, but I'm sure tomorrow we'll get to celebrate all of you who had your special days. Thank you so much for staying with us. Tomorrow, 6 a.m., we will be back with another dose of TV3 New Day. Enjoy the rest of our programming.